Good afternoon, everyone. Welcome to Jindal Global Law School's webinar series. My name is Prateek Bhattacharya. I'm an assistant professor and assistant dean here at Jindal Global Law School. And today we'll be discussing the topic of virtual courts and are they here to stay? Of course, no one needs an introduction to the fact that virtual courts have become the byword over the last couple of months because of the COVID-19 pandemic, which is spread across the country and across the world. And our legal profession has also similarly adapted to the crisis by opening up virtual courts by making it an accessible option to all lawyers and litigators and clients in India. To talk about this a little further, we have two experienced litigators with us today. We have Mr. Ankush Mehta, both from Cyril Ramachandran Mangaldas. We have Mr. Ankush Mehta, who's a senior partner in the dispute resolution team at the Mumbai office of Cyril Ramachandran Mangaldas. Ankush focuses on arbitration, both domestic and international arbitrations, and he has experience in corporate and commercial litigation matters, as well as in real estate disputes and private client related litigation. We also have Ms. Samiksha Pendekar, who is an associate in the dispute resolution team of the Mumbai office of Cyril Ramachandran Mangaldas. She has experience in litigation in both corporate and commercial and other transactional issues. She has experience as well from general corporate and advisory work, primarily focused on mergers and acquisitions, as well as corporate restructuring. Samiksha also is an alumnus from Jindal Global Law School and graduated from here 2 years ago. So without further delay, I think we can begin with a presentation. Our speakers prepared a slide deck today, and I'll just begin with that.
Okay. Are we ready?
Yes, I think we can begin.
Okay. Thank you, everyone, for tuning in today. Ankush and I are very excited to take this session. To begin with, thank you, Prateek, for agreeing to moderate this session. And it's so exciting to be back at Jindal in a virtual way, but that's the world we are in right now. I think I will let Ankush, take it ahead from here, and I will keep coming in as and where required. Ankush, over to you.
Yeah. Thanks, Samiksha, and a very, very good afternoon to everyone. Thanks, Prateek, for all the effort that's gone into making this possible. I think you can move on to the first slide, Prateek. I think the idea to literally, Samiksha and I have been talking about and doing a few matters, and also talking to clients about the possibility of how courts are going to, be in the new but unfortunate, era post the COVID, because this was, of course, not planned. And if one had planned it, of course, things would have been much easier and smooth, so to speak. Given that, of course, legal work, should not stop, and particularly the focus area that is for us, which is court matters, regulatory work, law enforcement related matters, and and things like that. These things will go on and on and on, because people are going to be in places where they require money. People are going to be accused of offenses, and people are going to fight for their rights as and when, and courts are meant to and of course have been and will be supportive of all these instances. So with that background, we thought it's very relevant to spell out that where we are at present in terms of the current day scenario. Really speaking, the how is the e-court thing going to play out? Then we've put together the practical considerations, and what is going to happen in terms of whether there could be logistical issues for filing. Is it what are the pros and cons of e-filing, and so on and so forth. And of course, whether this entire e-court system is actually new to the country, or was it pre-existing, and only sort of remain to be tested. So with these things in mind, I will first begin by saying that what is the impact of COVID-19 on the working of the court. So when we look at the word court, while there is the Supreme Court, who has probably the best, and it's the apex court of the country, and it has the best infrastructure, so to speak. There is of course the high courts, and there are many lower courts, such as the debt recovery tribunals, or the national company law tribunal, or the city civil court, the district court, etc., who are very critical in these, in the entire scheme of things. Samiksha and I were just doing a little bit of a study, from the Bombay High Court perspective, where we practice frequently, is that on an average you have about 800 to 900 matters being completed or heard every day. Just with that in mind, you can simply count the backlog that would have been there if for 2 months courts would not have been active. So while there has been an impact all across, on lawyers, on judges, on litigants, etc., even on the staff, courts have come up with solutions. While I can say that they are not fully functional as per optimum levels. I think the system to in our view is here to stay, where you probably have a hybrid system of physical courts and e-courts going forward. So with that, I think I'll just Samiksha will throw some light on the constitutional provisions, and what is the law on the subject, for e-courts and virtual courts.
Right. Thank you, Ankush. So before we get into the legislative aspect of virtual courts, I think one of the key aspects I would like to discuss, and taking Ankush's point a little ahead with regards to how many cases, how is the Bombay High Court in particular actually dealing with the virtual court system. So till date, the Bombay High Court has passed around 404 orders, and it is sitting for 2 hours with a bench strength of 5 judges. Now, in light of all this, we can kind of understand how the functioning of the courts is being dramatically, affected, especially since earlier they were kind of disposing of 900 cases a day. So now moving on to, the Supreme Court. The Supreme Court on April 6th passed an order saying that all the high courts have to work in a way to kind of enable the idea of virtual courts to become efficacious, and moreover to ensure that justice is not at any point come to a standstill. Now with that, eventually it moved on, and on May 15th, it came out with the Supreme Court's e-filing module. Now, what this module does is that it's a platform which allows you to file at the Supreme Court level at any time of the day. It's a 24-hour filing facility, which is available to lawyers, which is great because earlier lawyers could only particularly file during those office hours of, the court hours. And that would be extremely stressful. Filings are very laborious. And I'm sure as and when, you all join the practice as well, and especially those who are going to litigate, there you are in for a dramatic change, but a very welcoming and a very necessary change, one could call it. Also, another thing is that, just today in the morning, there was an article in the newspaper that came up to say that the Supreme Court has developed a special software to make 17 of its benches absolutely paperless. That means it's going to allow judges to access documents, access annexures, filings, all on a virtual platform, and they can make their notes there as well. So, and eventually they're planning on extending the same facility to lawyers. So we can see a very dramatic and a very conscious shift towards, the virtual system, or the virtual life, if one could call it. Now, moving on, I would like to, kind of highlight on some key variables of, the aspect of e-courts. Now, what is it that e-courts are bringing to us right now as we, are going on with the COVID pandemic and all the other ancillary aspects that are happening, and what is required to be done to actually make it a success. Um, First and foremost, the aspect of convenience. Like I mentioned, lawyers are always so, just to give you a brief backdrop, I'm not too sure how many of you all have actually interned in have done a litigation internship, but just to give you a brief background of how a normal day in a court goes on, like. So every morning there's a lot of rush, especially like 10:30, the main hours start, and then there's mentioning, there's always, lawyers are going in and out. There's this constant buzz from one courtroom to another courtroom. So this entire, litigation life is very hectic, especially within the court. What it's done is it's brought about a lot of convenience, at least now. I mean, whatever, in whatever way, lawyers are no more running from one court to another. They don't have someone, in a one court just waiting to see if their matter gets called out. It's more simple. And it's just, you're in front of a screen. There's no travel time anymore. Especially in Bombay, travel time plays a very important role because we spend like maybe 2-3 hours just reaching the court from some areas of the city. So yes, there is a lot of convenience that comes in, especially for lawyers. It also brings in a lot of ease in process, especially when it comes to filing. And like I mentioned, filing is a very laborious task. It takes hours and days of pagination, notarization, just making sure everything is in place. Just the entire process is now extremely simplified. But however, now though we are using the e-filing portal more, we have to give a declaration that says that we will be submitting the original documents to the court as and when it's possible. Then another key aspect, I think it would be that it brings in a lot of accessibility. Now, accessibility, why I say that is because, back in before the entire virtual court system actually came into, full force because of the COVID-19 pandemic, a lot of lawyers who would like, a lot of matters that would come not from the city itself, but from, smaller cities, not from not from Mumbai or Delhi, but like neighboring cities, or like further away cities. So now those lawyers actually have a chance of maybe arguing in front of any judge in Mumbai, because now that distance is no more a problem. So it does increase accessibility, and moreover, it increases accessibility for the litigants and the general public at large. However, that the general public at large aspect is something that we still need to deal with, and that's something that we will come to later in what has to be done. Prudent use of time, of course, if we are not, wasting too much time going in and out, if we are not wasting too much time in going from one court to another, we are anyways, utilizing our time in a very, very good manner. And this is something that, we have also realized in since the COVID-19 pandemic has hit. We have been practically in lockdown. Our offices are not operational, but we are operational. We are, utilizing our time utilization, at least in my opinion, has become so much better. Ankush, what do you think about that?
No, I think Samiksha, you've made some excellent points. In fact, about utilization of time. Of course, certain relatively older practitioners like myself, we are still, people are still getting used to the fact that you don't have the hustle bustle, as you said, of going to court every day and lining up in those queues, and in a lighter way, just a little bit of a struggle getting to the hearing. Immediately those troubles of monsoon, etc., are not going to be worrying
Yeah.
so much, and things like that. But on the other hand, of course, there are several benefits, where I don't think it's an ideal situation of working from the comfort of your office or your home while you're having an e-court hearing. I think I will say this, that it's of course great to have the physical experience of a court of law, and how really so many skills of advocacy, body language, the entire process, paperwork that goes in, it's a must learning, at least when we were growing up. But on the other hand, while that perhaps is some time away now, this could be, as I began by saying, and as Samiksha has very correctly elaborated upon, is could be really the new way of learning, and people will get used to this kind of a functioning as well. So litigation, I think, I mean, I'll be safely said, is not going to go away. And I think with more accessibility, with more reliance on technology. I know Samiksha has a few points to make there as well, so I'll give it to her very shortly. But there is going to be a good change, if we may call it. And at the end of the day, I think I mean, at the end of the day, if justice is served and the litigants are satisfied that their case has been heard, as opposed to probably coming from faraway cities and spending days after days waiting for their matters to reach at some point of time. It helps them to also factor in these things and adjust their time well. So I think a lot is being achieved. I also would like to say that a lot can be achieved. But Samiksha, you want to also talk about the example which you were talking about in your college days, and then how those small things really, when there's a little bit of a resistance to change, and finally how these things really work out for the benefit of really everyone.
Sure, Ankush. Thank you. So I was just discussing this with Ankush, a few days ago, that when I was in Jindal and, until the third year, we had a manual gate pass system. So, I was in SH4, so I would run down to my warden's office. I would, sign a slip. I would tell her, okay, speak to my mom and I'm out of the college. And I'm sure everyone who's attending, at least who's in Jindal right now, knows what I'm talking about. So in my third year, they shifted to a e-gate pass system. So we had to apply for a gate pass through a portal that they had opened, and that was the only way we could do it. So not just us, but even the wardens were extremely harrowed by the system. There was a lot of delay. People were claiming that they are going to miss their flights because, they are not getting the gate pass in time. So the reason why I think this is, a rather interesting example to share on this platform is because we have kind of personally dealt with how technology can, and adaptation to technology can, be a little hard, but it's not impossible, because by the time I graduated, it was like clockwork. I was getting gate pass right before I even reached the gate, my gate pass would be approved. So it's all about adaptability. But having said that, there's a lot of other aspects also that we kind of need to, understand. And especially for virtual courts, it's not as simple as a gate pass for sure. But the first thing would be an IT infrastructure. We will need a robust IT infra to ensure access and on a pan-India level. This infrastructure will also need to be supported by uninterrupted internet and electricity services. Now, this is the basic aspect of what we will require to make the virtual courtroom a reality for the long run. And like Ankush was mentioning, the hybrid system that we are envisioning, to come into play in the near future, we need all these things to be taken care of. Another aspect is the privacy considerations, because this IT infrastructure, which will, have the data of all the possible litigations that are maybe ongoing, or, the press filings which will be filed. So, and a lot of this will be confidential information. So we are going to require such a robust privacy, system as well, that this IT infra by no chance can be hacked or cannot be compromised. That is also another very important consideration that we need to keep in mind. Another thing is, about training. Everyone's going to require training. Court clerks are going to require training, litigants, judges, lawyers. The entire system by itself is going to now have to adapt to a virtual system. Now, this is a process, though not impossible, it will take some time. It is not something that we can kind of, just whip a wand, and it's not something that everyone can adapt to so soon. So we need to also understand as to why do we think that a hybrid system is something that is more realistic as opposed to a completely virtual system, is because of this. Everyone will not be able to adapt to a virtual court system. So if the accessibility is hindered, what is going to happen? Access to justice is going to be hindered. That is one of the key aspects also that we need to keep in mind. The other is digitization of matters. All ongoing matters, all fresh filings are all going to have to be digitized. Now, a lot of these matters are also in a regional language, so they will have to first be made into English, and then they will be digitized. So this process is again, a little cumbersome, but it is again not impossible. It is something that can be achieved. Ankush, is there anything you would like to add as to what is required to be done?
No, I think Samiksha, in summary, you've covered it well. I mean, touching upon really the what gets missed in the larger things, and what you've covered is the nitty-gritties really that need to be taken into account. And while of course many of the lawyers may be privileged to have more than one laptop, iPad, mobile through which they can connect, there may be others who may be more reliant on certain basic infrastructures which may or may not be accessible to them. As you rightly said, that whether in the lower courts, the district courts, whether these facilities will be available. Often enough we know that leave aside Wi-Fi or network, I mean, they don't even have electricity, and the things like that. So of course any change that is brought about takes time to settle. But I think in summary, to move on to the next chapter, one can say that this is probably the step in the right direction, and we need to show some patience and some faith that finally a hybrid system, as and when, in whichever form or shape it comes out, will suit literally everyone, end to end.
Absolutely, Ankush. Thank you. So now I will move on to the legislative framework of virtual courts. After the pandemic hit and after the Supreme Court's order, there was a lot of speculation as to the idea of virtual courts and whether it is supported by our legislative framework. While they made a distinction that since this is a pandemic, we have to make do with whatever we have. But then again, the argument, that was highlighted is that, is this something that can sustain even after the pandemic? Now, for this entire, debate, this entire speculation fall upon this one very important concept of our litigation system, or our legal system, as you may call it, is the concept of open trial or open court. What does open court mean? Open court essentially means accessibility to the court. It is a tool to ensure procedural fairness and transparency. However, it must be kept in mind that the concept of open court in its physical sense was, propounded at a time where digitization or technology had not reached where it's reached today. If you see our CPC, if you see our CRPC, like CRPC 327 or CPC 153B, what they say is that any place where trial is being held will be considered an open court, provided the general public has access to it and can be contained within it. So the idea of contained within it, then people said, is that no, that is the physicality of the aspect. That is why it is important to have a physical presence as opposed to a virtual presence. Therefore, a virtual court may never be able to satisfy the requirement of an open court. This entire debate went on so much that eventually, in May, the Supreme Court actually came out with a note analyzing the concept of open court and analyzing it in the light of the virtual court system. But that is something I will come to later. Before that, I want to take you back to 1966. In the case of Naresh Mirajkar versus state of Maharashtra, what had happened was the court had the question of allowing. Let me run you by the facts a little, so you also have a brief idea of what happened. There was a defamation suit that was filed. In that defamation suit, there was a witness who backtracked on his statement while in court. Now, later it came to light that the reason why he had backtracked was because if he had given that statement in court on that day, it could have, been detrimental to him for another IT case of his. So he asked, then he was again brought back to the court, and he asked the court that fine, I will give the testimony provided you let me do it in camera and you ensure that it is not publicized later. You essentially bar the publicity of that thing. No media access should be provided. Now, this the court had permitted it, but then it was challenged in the High Court by the same person against who had filed a defamation case. So now, in the Supreme Court, what the Supreme Court said was that when it is required for justice to be propounded, if it's required to meet the ends of justice, it is okay to give the it is okay to take a testimony in camera if that is what the witness requires. So after this, if you go to see 153B was actually introduced after this case. So it's not that the concept of open court particularly requires a physical presence of anybody there. I think it's more about the idea of accessibility. And that is what the Supreme Court in fact said in its May 6th note. Sorry, apologies. Yeah, sorry, May 6th note. Let me quote the Supreme Court here. It said, the traditional open court system in its physical manifestation and the new age virtual court system are not antithetical to each other. On the contrary, both systems could coexist, delivering qualitative justice. Then the Supreme Court held that, in its opinion, the concept of open courts actually just includes three aspects. One, accessibility of all parties to hearings. Two, right of the parties or their representatives to partake in the proceedings. Three, access to the public and media to court hearings and their outcomes. This entire idea and the entire note put out by the Supreme Court really set out what open courts mean, and the fact that the virtual court system is not something that runs contrary to that. So that brought to rest a lot of speculation in that regard. Having said that, for virtual courts to actually become a long-standing reality, we may have to look at amendments to certain acts, central acts, and also probably understand how is it that we can, regulate the idea of virtual courts, and how is it that it's going to be kind of dealt with on a more permanent level. Another interesting question that comes with virtual courts is whether evidence can be taken on virtually. So, in fact, though we are dealing with virtual courts now, this question particularly was dealt back in 2003 by the Supreme Court in the case of State of Maharashtra versus Prafulla Desai. In this case, what had happened was that the witness whose testimony they wanted, was a doctor based in New York. His patient, who he had let me run you by the facts again. There was a patient in India. She went to New York to take consultation from this doctor. The doctor said, you do not need surgery. We can treat you with medicine. She came back to India. She went to another doctor. The doctor said that, no, let's do surgery. She told the doctor, but the doctor in New York said that I don't need surgery. He said that, no, I think you need surgery. She said, okay, fine. I will agree to surgery provided you are the one who does my surgery. Now, when the surgery happened, it came to light that it was not the Indian doctor who told her who would do the surgery. It was some other doctor who actually did it. Eventually, there were problems and the woman passed away. Now, her husband, filed a case, and thereafter, the state wanted the New York doctor's testimony. The New York doctor said, I'm willing to give my testimony, but I'm not willing to come to India for that. In that case, then an application was filed to allow the testimony to be taken virtually. That would mean that it would happen just how I'm giving you this presentation. That's exactly how it would happen. It was allowed by the trial court. Then it was the order of the trial court was held to be erroneous by the High Court, and then it went to the Supreme Court. The Supreme Court held that Section 273 of the CRPC, which the the other party was really relying on to say that no, you cannot take such a testimony virtually, allows for the concept of constructive presence. What constructive presence? Why I say that is because of this. While the person who's accused needs to be present while an evidence is being given against him, it is okay for his pleader also to be available or present instead of him. So the court said that if you read the section, it does allow for the accused to be constructively present. So the physical aspect of it is not really there. It's not a necessity. It is something that will be great, but if it's not there, it is okay. So then after that, the Supreme Court allowed the testimony to be taken virtually, and since that time, several trial courts and several courts have relied on the said judgment to actually take a lot of evidence virtually, which would not be otherwise possible physically. Now, having run you by the legislative framework, and now that we've understood that virtual courts is something that at least as of now is supported by our legislative system. It is not something that runs contrary to the principles that we stand for. I think now it is a really good time to get into what the practical considerations of this are. By practical considerations, we mean that Ankush and I have been practicing for a certain amount of time, but we thought it would be very important for you all to understand what in practice does it mean, and what impact will it have in practice. Ankush, would you like to start with the key aspects of traditional litigation?
Sure. Can you hear me now? I was having a little problem earlier. Am I audible now?
Yes, absolutely audible.
Okay. No, so thanks, Samiksha, on going through the the other sort of relevant considerations. As I was saying in the beginning that traditional litigation was all about going to court, going from department to department, filing your papers, as Samiksha talked about, mentioning of a matter, so that it can be listed because listed out of turn or because of the urgency. There were so many other things in terms of simple paper management, packing of a basta or a brief, the previous evening, putting in case laws, putting in bare acts, managing the brief of the counsel, managing the brief of your senior, a lot of things, went in the back end before the matter, actually could be effectively heard. As we pointed out even earlier, for example, even the paper management, as we were speaking about, sometimes these things are taken for granted, and and probably your senior counsel or the judge will of course expect everything to be top in order, and a lot of time would be spent by junior lawyers, mid-level lawyers, and sometimes even senior lawyers, ensuring that matters are up to date, papers are up to date, and whatever is required for that particular hearing is also in readiness, because what can be asked by the judge or what can be asked by the senior counsel sometime in day, depending on if the senior counsel is briefed in a matter, can't be predicted. So essentially the point here is that you would go in full preparedness. Client is not going to be okay with the fact that you missed one paper here or one paper there, or that he's going to take the fact for granted that you filed and done your job properly, and that you're not letting him know about administrative issues, which can come up very very frequently when it comes to these kind of challenges. So I think the point really is that traditional litigation should not be sort of given a go by. I think it's very relevant, and it's not going away anywhere. Making the point or restating the point about a hybrid system, because by the time the records are digitized and you have everything literally available on the intranet, your emails, your software, your computer, your laptops, and so on and so forth. Traditional litigation is going to remain, especially when matters which are which are going on for many years, and there are very heavy physical records which need to be referred to by a court, by a lawyer, by a client. These things will take time. But as far as new matters are concerned, I think slowly courts are changing their rules, their procedures to accommodate e-filing. Wherein while they are saying that you may need to file the physical copy, but for the time being, they will get by with the e-filing process. So I think traditional litigation, of course, had its own fun and had its own challenges as well. But I think with the sort of onset of the time where all of us, including lawyers, have had a lot of time to assess, analyze, and internalize, how do you want to best take the legal profession, forward. These probably will be interesting times. So Samiksha, you may want to just talk about hybrid courts and, rate of disposal, etc.
Absolutely, Ankush. I completely agree with you that, the aspect of the physicality of the courts is something that's really, really interesting. And, the traditional litigation system is something that, gives you that satisfaction, and, I've, from experience and at least what I believe, when we are in court and when we see other lawyers, argue, when we see how a judge is, kind of feeling towards an argument, there's a lot you learn. The traditional litigation aspect, it's a whole different ball game as opposed to the virtual one. However, the virtual one is what we are at right now. This is the reality, and this is where we will be moving towards at a faster pace than we earlier imagined. So where I think the hybrid of e-courts and physical courts will kind of meet is where matters such as procedural matters or mentioning is something that I think will move towards the e-courts. As opposed to criminal matters, they may be still required to be done in a physical court as opposed to an e-court. Especially, and another reason why the hybrid, court system will be necessary is because, see, the COVID pandemic is not going anywhere until a medical solution for the same is found. By a medical solution, I mean a possible vaccine. It is harmful for lawyers it is harmful for anyone who is above a certain age. And we do have a lot of lawyers who are practicing, and, as they say, the older you get, the better you get. So some of our best lawyers may not be able to come to court mainly because of the COVID-19 pandemic, and that can be dangerous. So, those lawyers as well is something that the hybrid system will kind of, address. Another thing that, what we think will be a definite change is the way the lists are scheduled. There will be staggered hearings. There will be, slots that will be provided for, a number of hearings. Okay, so hearing 1 to 4 will happen from this time to this time. There's another aspect which we hear that they are seriously considering is the slotting of the type of matter that it is. So final hearings will happen during a certain time. Other hearings will happen during a certain time, just to ensure that the court is never really overcrowded. And I'm sure if any of y'all have ever actually gone to a court, you will realize it is often very crowded. The litigants are there, the lawyers are there, the clerks are there. There's just always a lot of physical movement, a lot of physical interaction that happens in a court. Now, that is something that we cannot, sustain with, especially if we have the pandemic going around. Another thing, like I mentioned even earlier, is that, mentioning of matters should definitely move on to the virtual system. Why? Because mentioning is one of the most crowded times in a court. Like, all the lawyers are, are waiting in front of the judge to mention their matters for the same day, and, so on and so forth. So that time is something that should definitely move on. That procedure is something that should definitely move on to the e-courts system. Another thing is that, the from what we believe, the high courts are actually very seriously considering the idea of facilitation centers. Now, what will these facilitation centers do? These facilitation centers will be spread across the state. They will be providing the IT infrastructure to people who do not have the basic IT infrastructure to participate in a virtual hearing. By a basic IT infrastructure, I mean internet, a phone with a camera, access to any other requirement that may be, needed for a virtual hearing. Also, what I feel is that the facilitation centers may have to consider also, providing for the ancillary provisions, such as, a provision for scanning papers, and ensuring that the people who do not have the general access, or who do not have what their counterparts have, are able to kind of sustain and are able to go on, instead of being uh, prejudiced essentially by the fact that virtual courts have now come into play. Ankush, what are your thoughts on this?
No, so as I said, I agree that these are things that I can say that we can have some experience just going by the past and some foreseeable future. Unfortunately, fortunately, in this kind of a situation, literally all seniors and all juniors and all lawyers have literally started from the same starting point. And there is no sort of advantage, or there's no sort of head start that anyone has had. Of course, to be very fair, larger firms like ours are better equipped, and if you realize that it's been so smooth working from home, that there's been very minimal disruption in advising clients or coordinating within ourselves. And of course, but as I said, that where I don't think an e-court or a virtual court at the end of the day can be said to be an identical substitute for a physical court. And I know that you are going to touch upon this in the following few minutes, but when it comes to a trial or when it comes to something else. But again, I think I want to just leave this thought with the audience to say that is it really probably what Samiksha was saying in the beginning, when she spoke about her access into Jindal in terms of whether you needed a physical slip or you could do it over your phone, and there is an initial resistance, an initial block, and is it really a mindset issue, or is it something else? Of course, time will tell, and we're all hoping, as I said once again, for the best. But really that's where I want to leave these thoughts with the audience.
Right. Thank you, Ankush. And if I may just
If I may just
yeah.
make a housekeeping announcement for those who have queries from the audience. I know I can see some hands have been risen and some people have questions, so we'll just be addressing that towards the end. For those of you who have admission related queries, they'll be responded separately to by our JGLS admissions team, which is working at the back end and receiving your queries. Sorry, Samiksha, you can continue.
Not a problem, Prateek. Thank you. So we'll just move on to another key, practical consideration that one must keep in mind is with regards to the reduction in filing. Like how Ankush has already discussed that, the courts are only taking on urgent matters as of now. They are not, filing for all matters are not being able to happen. In that light, there's obviously going to be a substantial reduction that we are going to see. However, this time may also be a very key time to deal with the backlog that the court already has. So even if new filings are not being done, this can be a golden opportunity to kind of try and reduce the backlog that the courts are already overburdened with. This is actually something which I must say Justice Patel has very strongly, advised and said that, this is something that we should definitely look towards. Now, another aspect that I'd like to discuss is with regards to written submissions. written submissions are something that go on for pages and pages, and lawyers like would practically put in all that they have, everything that they can consider, everything is in their written submission. But now, since we are virtual court system, and the hearings are going to happen virtually, the judges are anyways overburdened, because it's not that easy to kind of conduct hearings through screens. Like, I was attending another session by Justice Patel himself, and he was telling us how it gets really daunting for judges to keep understanding, keep their eyes on the screen, keep looking at and tracking so many people at the same time. They also have the control over who they can mute, who they can unmute. So it's a lot happening at the same time. So for them to be able to kind of just concentrate on what oral submissions are being made is not that easy also. And in that regard, then he said was that, what would be really nice is brief and succinct written submissions. Or there are two ways you can go about it. One is that you do, you make your key points orally, and you tell the judge that, okay, while I'm sticking to just my key points orally, I'm going to give a more detailed pleading by way of my written submission. Or you give a really succinct written submission where you just mention exactly everything that you have to say in brief, and to the point, instead of touching upon everything that you may have to, and you make that, you substitute that with the oral out in the oral hearing. So I feel like we as lawyers also have to kind of adjust to this in this regard. We cannot go on the way we used to go on back in the day. Times have changed. There's a new wave that's kind of come along, and we have to ride it. There's no other option. And now, talking about how lawyers have to change, I think there's going to be a very, very drastic change in the way we kind of litigate. The change in our way of advocacy. That I say is because, if you attend a hearing in court, you will notice that often lawyers interrupt each other. That cannot happen on a virtual court anymore, because the judge simply puts you on mute. So if you're on mute, you cannot interrupt. So that is absolutely gone. You cannot bring on records in the middle of a hearing anymore, as several lawyers would sometimes do that, though that is not something that is particularly suggested, but a lot of them still did that. They would just present a document in the middle of a hearing. That is something that cannot happen at all anymore. Another really interesting aspect is about, how will a lawyer take instructions from its clients? Because now what is happening is that the virtual court system, as we are seeing it run today, you are given one link or two links max for every hearing. So now either the link is with the lawyer's assistant, or the litigant. How are you going to divide that? How are you going to coordinate that is something that is still being developed by lawyers on their own, and they're still trying to understand what is the best way to ensure that instructions are being able to be taken by the litigant. Another thing that I would like to definitely touch upon is the idea of cross-examination. Cross-examination, it's an art. It's not just a practice. It's literally an art. How does a lawyer cross-examine a witness in court? Is by creating a certain environment around the witness. It is not simply going in, and it is a very cross-examination is a very important part of trial. It can either make your case or break your case, literally, because the way you are able to procure the information from a witness plays a very, very important role. Now, lawyers create a certain atmosphere around the witness. They sense the witness's body language. They kind of understand, okay, so, this is where the witness is kind of telling him, maybe this is where, I can ask this question. So it's a very calculated practice. It's not something that, is just, it's not as simple as just putting questions out there. How you put out the questions, everything plays a very, very important role. Now, when we are virtually doing this, lawyers are not able to understand the witness's body language as well. They are not able to create that particular environment around the witness. So the idea of cross-examination is again something that's going to see a very, very drastic change. Now, talking about witnesses, another thing I like to discuss is that, there was a study taken on by the Australian High Court where they tried to kind of experiment with the idea of, virtual courts and, whether e-courts can be something that can be a reality. So for that, they ran a study on a few witnesses whereby, some of the witnesses were told that, okay, you have a camera that will be shooting you and people outside of the courtroom will be able to hear your testimony, as opposed to the other lot of people who were not told about the camera at all. So what turned out as a result of the study was that the people who were told about the camera were unable to pronounce the facts correctly, even though they had done the same thing prior. So there was a certain subconscious impact that it had on the witness and its ability to propound or to pronounce the facts. And that can be a very detrimental, impact on a trial. Because if the truth is not, if the witness is subconsciously impacted and is unable to pronounce its own testimony, it can literally, flip the case completely. So these certain considerations are also, very important to keep in mind. As Ankush has already, kind of discussed the changes of mindsets. I completely agree with him that, this entire system is now giving us an opportunity to actually change the way we look at it. It's not going to be easy. A lot of lawyers, like, as experienced as Ankush, they have been working or in a certain way, in a certain, system for a substantial amount of time. However, people like y'all, students who are about to join the fraternity now, y'all are it's highly beneficial for you because you don't have to unlearn anything. What you're doing is essentially learning an extra aspect, which is even better, right? Because you don't have to go back and be like, okay, this is what I'm not able to do. This is what I'm not able to do. Especially students, all you all will be able to do is kind of steer your way through it. So I think this is a very exciting time for students and for new entrants into the fraternity specifically. Ankush, is there anything you'd like to add?
No, I think, pretty much covering everything. You may want to either at this moment or, as per the, slides, you may want to just talk about, the matter that one or two matters that you're working on, and how you're gearing up for filing. And on the one hand, of course there's an excitement to it because these are the first few matters that are literally coming up, for hearing. But at the same time, to gear up for preparation in terms of making the pleadings succinct, as you said, and ensuring that the judge reads the limited but the most important parts of the brief. The preparation that's going behind. I know it's a little early stages right now, but I think safely said that we are all equally, I think we are all very driven to ensure that at the end of the day there is no difference that we see between a physical or an e-filing in terms of the approach, the way we will approach a draft, or the way we'll approach a strategy and things like that. Because for us, finally, I mean, we need to get the client home. For example, even the briefing sessions, Samiksha and team, and we've been having, or anything to that effect, literally virtually or physically, I mean, we pretty much run the same thing. We'll still have a chat at 10 p.m. at night or at midnight or early morning, and those things just don't change. It's instead of just being in the office, we'll just probably do it from the comfort of our house.
Right, that's so true. So Pratik, we can move on to the ADR aspect. Ankush, would you like to start on this?
Yeah, so again, I mean, practically, a lot of a lot of clauses, in the agreements that our clients enter into have many waterfall clauses where it talks about either mediation to precede an arbitration or a conciliation or a good faith negotiation, as the case may be. I think earlier access to justice was easy in terms of going to a court. I don't think the access to justice point is an issue, but really going to the court with the challenges that we've listed out and the optimism levels that we have. I think keeping a balance in mind, it may well just mean that clients may lay more focus on really abiding by these clauses, and either going into good faith negotiation with full well meaning, or arbitration or mediation or conciliation, or finally may resort to arbitration, more so than sticking to a court of law, if at the end of the day the hearing is going to happen in not so much of a distinct way as earlier an arbitration in a court would happen. So, with that sort of consistent approach and mindset, I think clients may just opt for, going down the alternate dispute resolution mode. So, yeah, Ms. Samiksha, you can take the following.
Right. So taking it forward from what Ankush has just said, like we are currently actually doing a matter where we are about. So it's a multi-tier dispute resolution clause. The first step is mediation, and then it is conciliation, and then it moves on to arbitration. So given that the dispute is happening during the pandemic time, there's a certain shift that we've also noticed from the clients, that they do want to first undertake procedures such as mediation, conciliation, and then probably move on to arbitration, or even if later in other matters if it comes up litigation. So the either how mediation, we believe that mediation and negotiation can be game changers, especially when we are dealing with a system such as a pandemic, because firstly they are not particularly governed by any system, or there are no rules. So the parties are actually free to kind of set up the mediation or the conciliation according to the best way or the best suitable aspect to them. It is also extremely cost effective. We know that the economies are, around the world is highly affected because of the pandemic. I think this is a very good time for ADR to, kind of be considered as one of the main, dispute resolution options available to clients. And we are also we also advocating towards the aspect of mediation and conciliation, because we think that it is going to help our clients get faster resolution, and that, as Ankush said, that is our prime motive, to give the best advice that we can, and ensure our client is satisfied and gets what the client intends to get. Having said that, coming to arbitration now, the LCI rules, the ICDR rules, all of them have already, kind of since before the pandemic also have kind of in some way or the other supported the concept of virtual hearings. LCI rules allows you to undertake hearings in any way which don't particularly require physical presence. You can also take a witness's testimony through virtually without requiring a physical presence. Similar provisions in ICDR as well. So the support that ADR can provide, especially in this time, is unmatched. And I do not think, though there's always a certain, especially in India, there's always a certain understanding that no, let's just go to court. That's just going to be better. We just have more faith in the litigation system as opposed to submitting their disputes to a mediator or a conciliator. But now we see that shift happening. Now they're like, okay, fine, we may consider mediation. Let's at least try it out. Let's figure if that is something that we can do. So I think this is a very conscious and effective shift that's happening. And in the long run, I think it's going to be very beneficial in also lowering the burden on the courts. It may also reduce the frivolous hearings that may frivolous filings that may happen. So I think all in all, we are headed to a really, really exciting time, and I think especially as students, you guys should be very open to the idea of litigating in this new era, because you truly have an upper hand, and if you play it well, you can the sky's the limit. So having said that, I think Prateek, now we can open for questions.
Samiksha. I'll just thank you so much, first of all, for to both you and Ankush, for some excellent points. I know that the many of our current students are wondering as to whether litigation is a true option for them, and I think this would have answered a lot of their queries. Just give me 1 second.
Not a problem.
So a question which we received is, are there any particular subject areas of law which one would have to acquaint themselves with to effectively deal with dispute matters that might crop up post this lockdown? I think this is a trigger towards a situation of more contractual breaches, as we've been seeing that there are there's a possibility of more contractual breaches, and reliance on vis major as an argument which may arise post lockdown once courts reopen. So what are the subject areas which people should prep themselves on for this?
I think Ankush, please take it.
Go ahead, go ahead.
No, I'll tell after you. Please.
So I think in terms of just subject matter material, it's been my just to give you a background. I mean, I cleared from government college, and I did my solicitor's exam after that. You would be familiar with that, but and I'll make the point very soon about how to connect the dots here. I was talking to, yeah, at one point of time, he was a current judge of one of the high courts in India, who I used to play a game with, and some other senior counsels. And I actually asked them that, does it make sense to do your solicitor's exam thereafter? And the answer was very, very fascinating. To which, I mean, I'm reaping the benefits even today, which is that the more you study in law, and the more subjects you study, you will be very surprised that no learning will go waste. You will be surprised that a learning and experience on one matter will help you tremendously on another matter. So while the point now to address what I'm addressing question is that elementary principles of contract act, etc., will of course be relevant, but at the same time, just because there is a pandemic, or just because you may want to look at issues of frustration and force majeure, doesn't mean that equal and not more important given to so many other laws which a wonderful college and institution of yours has given you. So again, things like company law, like registration, stamp duty, things like CPC, arbitration, things will just not go away. And so the point I'll make is that while you may lend a little bit of relevant importance right now because it's a little seasonal in terms of focusing on provisions of force majeure or frustration, I would not base it only on that. I would rather use this time to familiarize myself on each and every aspect of the law, and of course spend more time on what interests.
Thank you. Samiksha, any additional inputs on this?
No,
point?
I think Ankush is the expert on kind of directing us and everyone else into, what fun's perspective should be. So I think I'll let them just be with his answer. I think he has done it pretty well.
Sure. So we are running short of time, so I'll just address one last question, and this is, I think, resonates with one of my own queries regarding virtual courts, because I again come from a background where I've done the grunt work in various courts and had to carry all the bags and pothas. So virtual courts are very new to me as well. So would you say, because of the resources which are available to larger law firms, and I think this is a point which you touched upon, would an independent practitioner be equally placed to people from which who have already set up a law firm to rely on, resources to rely on? And this is, of course, I'm asking this question because I know that a lot of our students who would plan on doing litigation after they graduate in 2020 or next year in 2021.
Right.
So,
Ankush?
No, Samiksha, go on.
No, please. I'll definitely make a point.
No, I couldn't catch the entire question. I'm sorry. Was it on infrastructure, or I couldn't catch the?
It wasn't on infrastructure, Ankush. It was basically about what are the opportunities, or what opportunities would an independent practitioner who's entering the legal profession be able to catch up to the resources larger firms such as yourselves have at your disposal?
As I said, I don't see any handicap, when it comes to an individual or an institution. I think of course an institution or a large firm like ours will have its inherent benefits, but at the end of the day, you will have to sort of have your own limited infrastructure in place to be efficient, to convey your advice to the client and plead your point to the court. I think that's a minimum level of requirement. And I mean, on an average, I mean, the people that I've had the occasion and the opportunity to work with in my team or elsewhere, I've literally normally found that level of infrastructure is available. We're not expecting anything in terms of a super specialist, infrastructure level. Of course, may all of you all do extremely well in your careers, and may you have more than one matter clashing at a time, and may you have more than one laptop required for you to attend to your hearings. Of course, those will be my, my closing, my sort of parting points.
All right. Thank you very much. I mean, just to spin off from that point, is there something which a person who's entering the legal profession needs to keep in mind with regard to virtual courts? For example, how to gauge the judges' reactions, and possibly, because as part of court craft, gauging the room, gauging the reaction, and altering the way you are making an argument. Is there something which they should keep in mind, or something regarding court etiquette which needs to be followed for someone who's jumping into the legal profession in this virtual world?
So court etiquette, I'm sure that there was a video that went viral where somebody had appeared before a high court is very, very comfortable loungewear.
Yeah.
Miss the requirements of how you should be appropriately dressed in front of a court. So that's not something I'm going to support at all. But at the other hand, we've grown up really looking at our matter and basically sifting through documents and pleadings and laws and case laws and what is familiarly called burning the midnight oil night to night. So I think once that there is enough experience of doing this time on time, one generally gets a hang of things. So there is no preset rule or determined rule that okay, you need to look at a judge's body language. I'm sure that once the profession has welcomed all the younger lawyers, and they are a part of it, it's probably going to they just breathe that air. It's just going to happen very naturally, as it happened to all of us.
All right,
I like to.
Please, Samiksha.
So I was just saying that, like Ankush has said, there's absolutely no one formula fits all kind of a situation in this. It depends on who you are in front of, who your judge is, how he reacts to a particular, matter. So all I would say is that, when you're going in for a virtual hearing, just be prepared, because it may not be as, fluid as a physical hearing. Have that in mind, speak slower than you would in general, because there might be a technical issue that might, one of the parties may be facing it and you are not aware of it. Like I'd mentioned earlier, don't interrupt. Don't try and bring records on, documents on record in the middle of the hearing. Don't unmute yourself when the judge has muted you. Just these few hygiene points, and I feel like you will be okay. Just keep in mind that this is not, the person is not in front of you. You're seeing him through a screen. So be aware of that fact. And I think if that is your starting point, the other things will just fall in place. I think that's something you should keep in mind.
All right, great. I think that concludes our webinar for today. Thank you so much, Ankush and Samiksha, for joining us today and for being speakers at this webinar. Thank you everyone who attended, and we hope to that you'll attend our other webinars organized by Jindal Global Law School. Thank you everyone, and stay safe, stay at home.
Bye.
Thank
Thanks.
you. Bye.
Bye.